Aloha mai kako. So today we're going to cover traditional and customary Hawaiian rites. And we're going to trace their origins first in the customary law of Kava Kahiko during the ancient times, and how these customary laws were codified by the Kingdom of Hawaii and survived into statehood. We're also going to cover certain cases on Native Hawaiian rights. And then later in class, we'll be going through different kinds of hypotheticals to really put your new knowledge to use. So let me begin by describing these main sources of law. So they exist in Article 12, Section 7 of the Hawaii State Constitution and in our various statutes that survive from the kingdom period, such as the Kuleana Act, now known as Hawaii Revised Statute 7-1. And then the previously known Judiciary Act during the time of the kingdom, now codified in the state law as Hawaii Revised Statute Section 1-1. And then there are relevant cases that speak to how you actually apply these laws. So really what's key to understanding Native Hawaiian rights is to go to the core of what made Ahupua'a vibrant and thriving. And it was the Maka'ainana, the people of the land. And really down to its basics, it is the ohana, the family. And so Hawaiians were known to have extended ohana, and there were ili, strips of land within the Ahupua'a where the extended ohana lived. So Mary Kawena Pukui, revered kupuna scholar, she talked about the life of the families, the extended ohana in Ka'u, where she was from. And she talked about the ohana ko kulauka, the ohana in the mountain area, and they farmed kalo and they gathered things from the forested areas. And then you had ohana ko kulakai, those who fished and gathered limu and crabs. So there was a lot of barter between the extended ohana. And you know, during times of conquest, it was always the ali'i, the chiefly class, that came and went. But it was usually the ohana that stayed in their ahupua'a and their moku for many, many generations. So those who have the intimate knowledge of the aina are usually the ohana and those who are of the maka'ainana class. So how I understand Native Hawaiian rights is, you know, it's rooted a lot in the traditional practices that I grew up with on the island of Molokai, where I'm from. And this is a picture of the southeast shore. And, you know, I grew up in Kamalo, where the Kiha Kapuale protected us. And I learned a lot of things like crabbing and fishing in Kamalo as a young child, laying net. You know, and these are the children of Kamalo. So a lot of times we would go on a flat bottom boat and lay net or spearfish. And that continued on, you know, after my mother passed and me and my brother moved to grandma and grandpa's house in Ualapu'e. And so I got to know these ahupua'a very well. In the latter part of my childhood, I spent my days in Ualapu'e, so I feel even like more familiar with Ualapu'e than I do of Kamalo nowadays. But when you read the book, my chapter in the book, Nourish, what I tried to do was give you a sense of understanding Palena, understanding the different boundaries. And I really like this quote from Dr. Beamer, Kamana Beamer's master's thesis, Huli ka Palena, And in that, he quotes Kahete, which says, indigenous people are people of place, and the nature of place is embedded in their language. The physical, cognitive, and emotional orientation of a people is a kind of map they carry in their heads and transfer from generation to generation. So when I read this, it totally made sense to me because of that mental map I have in my mind of where the different boundaries are. You know, and our ancestors, they also had such an intimate knowledge of the different winds and rains. So this is a wind map with all the different Hawaiian names of winds, and this made a lot of sense to me as well, because I really know the winds in a kind of intimate way. I didn't realize I knew this until I moved to the state of Washington when I was in college, and there was no continuity to the winds. And I thought, these winds are crazy. But because we have regular trade winds, you know, and we're in this sort of belt where you get the Coriolis effect, our winds are very predictable and our rains are very predictable. And so Dr. Beamer cites in his thesis traditional knowledge of the special names of specific winds, clouds, and rains. One example he uses is the rain that is exclusive to Manoa, called Tuahine, and the rain exclusive to Palolo, called Lililehua. He said that knowledge of Palena would enable a person to know which of the two rains one was experiencing. Embedded in that person's ike is a mental map. And Dr. Beamer tells the story of an interview with a kupuna and a simple question of where she was born. He assumes that she is from the ahupa of Waiapuka on Hawaii Island, but she corrects him and says she's from Halili Palala. He's confused, but after further research, he finds that Halili Palala is 500 feet away in actual measured distance. But for the kupuna, there's a big difference. For Halili Palala is an ili in Niuli'i, not Waiapuka. So that level of intimate knowledge you can tell from talking to the old timers or those who really know their ahupa, who particularly live in what Dr. Daviana McGregor calls kipuka. So these sort of oases of Hawaiian ike that continue to be preserved and is a treasure trove for all of us, you know, as we learn more about our culture and traditions. So in the book chapter that you read, I also described my fishing grounds. So just to kind of show you a visual of that. So this is Kilohana School, this sort of big grassy area. So Kilohana, this is Kilohana Elementary School where I went to. And then from the aerial view, you can see Kilohana here. And right across the street was where my grandmother lived. And we are in Ualapu'e, Ahupua'a. So there's a stream. So this Ahupua'a here is, why am I forgetting the name? It'll come to me, but the Ahupua'a is just a stream bed. So on this side here is my great-grandparents on my mom's side, their land, my Bikoi family. And so I had access to two Ahupua'a. My grandmother, only being from Ualapu'e, she would never traverse beyond this stream. The stream is Kahana Nui, and the Ahupua'a is Kahana Nui. So this Ahupua'a here is Manawai. And this will be important as I cover the Kalipi case. So Manawai is here, and then Ohia is here, and then you got Ka'amola, Ke'awanui here. So the ahupua'as are very close together, but because of, continual access and use of our area, that mental mapping was very much solidified in my brain. So the Kilohana school is here. Grandma's house is kind of just above the shoreline. There's a little fishing trail we travel. And this is Ualapu'e fish pond. So we would go crabbing and pick limu all in this area up until where the Kahananui stream enters into the ocean. So all our limu beds, our crab beds are here. Sometimes, grandma would go crabbing inside the fish pond. So we had rights here. And so when we would go fishing, my dad, my brother, and I would walk along the Ualapu'e fish pond. This is all mangrove. So actually the end of the fish pond is here. And we would never go beyond that. My dad said, we got plenty in our own place. We don't need to go into these other areas where the other Hawaiian families live. And so I just knew that the end of this fish pond was the end of our ahupua'a. And sure enough, the end of this fish pond signals the beginning of kalua'aha ahupua'a. So kalua'aha runs along this area, and then it becomes eventually mapulehu, kind of like where this airplane wing is at the base. That's when we start entering mapulehu. So we would dive all along the inside of the reef, inside the breakers, and then we would end up here at Huaka, which is a blue hole. And after the blue hole, we would head in. So the beginning of this fish pond, or the eastern rim of this fish pond, is the boundary line from Kahananui, and it goes then after to Manawai. And so we didn't go beyond this fish pond. So it wasn't like my father said, now children, this is Kahananui, this is Ualapu'e, this is the end. We just somehow knew that we had to just stay within these boundaries. So that's kind of like my visual markers to the palena of my place. And my great grandmother used to live in Manawai. And there's an orange tree that everybody that hikes and hunts in this area praise this orange tree that my great grandmother planted. Is the sweetness of that orange tree. So, we didn't fish in this area, but we would traverse the mountain areas. There were different heiau all along this place. So we did have that feeling of freedom to go in this area as well. So, there were different markers of where I determined where the different heiau are. The kapa making heiau, the other one that was more like navigation, kilo kaing heiau, and then paku'i heiau, where the prophecy was made. So growing up in this kind of area, you really get to know your ahupua'a and its palena and features. And so in Kumu Beamer's master's thesis, he also talks about the first indigenous map that shows that high knowledge. So this was by S.P. Kalama. So you can see he knows all the names of the different ahupua'a of Maui, the ahupua'a of Lanai. And so this represents, strong indigenous knowledge. So, in Kumu Beamer's research, he had expected some kind of correlation in Hawaii with the influence of the missionaries and foreign advisors. But as he looked at the maps, made during the Mahele, he saw a wealth of indigenous knowledge embedded in the mapping. And you don't usually see that kind of level of understanding in like the United States and their maps. It doesn't have the Indian tribal names of their palena. So he talks about colonial mapping. Surveys were used as a means to bound the native and enumerate and enframe the power and wealth of the colonizer. So Hawaii is unique in that our surveys were completed under the authority of the Hawaiian Kingdom, an indigenous run government. So Dr. Beamer notes that while foreigners did a lot of the surveys, a lot of them were also carried out by Kanaka Maoli. Every ili of whatever type had its own individual title and was carefully marked as to their boundaries. And at the time of the government survey made before the land grants of 1848, it was found that every community there were individuals who were versed in the local lore of land boundaries, rights, and history. And so Dr. Beamer uses this map of Lahikiola. And these shows, certain blue squares represent ahu or stone boundaries, and red squares represent tree boundaries. And so you can see that this represents a lot of the indigenous knowledge as compared to when you look at colonial mapping, like this is the four corners, Utah, Colorado, Arizona, and New Mexico. And I really would think this is not, this does not represent indigenous knowledge, these square boxes. A lot of the features were, a lot of the mental mapping by indigenous people have to do with looking at, how the creek flows, how the streams flow, different features you see on the terrain. It is not perfect squares. So that kind of gives you the understanding that, a lot of the knowledge of Aina is embedded in the Maka'ainana, who for generation upon generations of time immemorial usually stayed within their ahupa'a, or at least within their moku. So as as the kingdom began to form, one of the first passage of law was the 1839 Declaration of Rights, which was incorporated into the 1840 Constitution, providing that nothing whatever shall be taken from any individual except by express provision of the laws. So there's this case, Rapun, that basically interprets that and says, prior to the Mahele, all land remain in the public domain. So this constitution, the 1840 Constitution, is significant, where it says Kamehameha I was the founder of the kingdom, and to him belonged all the land from one end of the islands to the other, though it was not his own private property. It belonged to the chiefs and people in common, of whom Kamehameha I was the head and had the management of the landed property. So what does that mean? Does it sound like how property law is in the continental United States? Or does it sound more like a trust? So a trust basically has a trustee that does not own property per se, or whatever assets the trust has. The trustee has to manage the property or the assets in such a way to benefit the beneficiaries. So when you look at this constitution, what the kingdom is saying is the mo'i, the king, doesn't own the land, but he cares for the land in trust for the chiefs and the people. So when you learn property law, you only get what the previous owners got. So a lot of land in Hawaii, the landowners actually don't have perfect title to those lands. They're encumbered by this trust relationship, which really originates from the understanding of the Kumulipo, and that the Ali'i were those that were closest to the Akuas, to the gods. And so they had kuleana, they had responsibility to care for the maka'ainana and to govern them righteously. Otherwise, the maka'ainana would move away and basically the land would fall into neglect. So where you see pono, when you see ahupua'a thriving and flourishing, the people flourishing and much abundance, or aina momona, fat land, that is an indication of good leadership. And so there was kind of a checks and balances that is really important to understand, whereby the chiefs were expected to be benevolent and caring of the people. And then the people themselves made the land fat, made the land abundant. So there was sort of an implied contract, in a sense, between the different classes, yeah. So what this constitution does is it codifies that understanding into law. And so the mahele, if you read Kamana Beamer's work, Professor Beamer's work, you'll find that when he looks at the mahele, he shows that it's kind of a hybrid system. It's infused with this mana'o from ancient times, and the kingdom adopts this understanding. So even though there was a division and privatization of the land, there were certain things that encumbered the land, and that was the rights of native tenants. So you often see this language reserving the rights of native tenants. Kornai no kuleana ana kanaka maloko. And what also happened during the time of the mahele was this Kuleana Act. So in the division of the lands, first the lands went to the king and the chiefs. But even though they owned large swaths of land, like entire Ahupua'a, all the land was subject to the rights of native tenants. The final part of the mahele was giving the maka'ainana option to make a claim for their kuleana, which was like 1 or 2 acres of land that had their house, the taro patch, or some kind of agriculture gardens on the aina. And so that was called their kuleana. And so for those who claimed their kuleana, they were protected under the Kuleana Act, Section 7 of that act. And in 1850, the act was promulgated and then amended in 1851. So the only difference between the two was in 1850, the law stated that the maka'ainana had to seek permission from the landlords, or what were the chiefs or whoever owned these large ahupua'a. They were then called landlords instead of ali'i and konohiki. So they said whether landlords have obtained or may hereafter obtain a lodio, or like fee title, to their lands, the people on their lands shall not be deprived of taking firewood, house timber, aho cord, thatch, and tili from the land for their own private consumption, yeah? And And then they also had a right to the drinking water, the running water or streams, and the roads and trails. Okay, so what does this law tell you? When you look at these specific enumerated items, they really are the very basic necessities. So the reason why the king insisted, King Kamehameha III insisted that this law be attached to the Aina, because in the Privy Council notes, they said, the king said, a little bit of land, even with a allodial title, if they be cut off from all other privileges, would be of very little value. So what does that mean? Simply like poho, it's a waste to even have a piece of land, your kuleana, if you cannot traverse Mauka and Makai, you cannot traverse through your ahupa and get the things that you need. So, when you look at kuleana land, some are really like landlocked. Yes, you can grow your garden and have a house, but you still have to go get these items that are necessary to your living. And so the king recognized that, and that became the Kuleana Act. Initially, they said go get permission, but what happened was there were certain landlords that were depriving the Makaainana from going up in a forest to get firewood and things like that. And so it was affecting their ability to cook, and they were starving. They cannot eat raw taro and raw sweet potato. So the Makaainana sent letters to the king and said, King, the chiefs are not honoring this law, and they're not giving us permission, and we're suffering. And so then what happened was in 1851, they amended it to remove that permission part of the law. And so this law survived into statehood. And there will be important and key to understanding the different cases that arose out of this act. So this is also the Pash case, and so this is where it's described, where the king says a little bit of land, even with a allodial title, if they were cut off from all other privileges, would be of very little value. So again, the cases cite to the different laws. And then, as I had stated earlier, initially the 1850 Kuleana Act, which required the people to get permission from the chiefs. This is a petition of 54 Hawaiiana, or native tenants of Kaneohe, Oahu. And so you can see, they're saying the children are eating raw potato because of no firewood. Their mouths are swollen from having eaten raw taro. So this is what basically changed the law to not require permission. Okay. And then again, so you have the Kuleana Act, and you have this reservation reserving the rights of native tenants. So what essentially happened as we looked at cases where now you got private property owners and developers trying to limit the use of their lands. They're trying to limit Native Hawaiian cultural rights and practices. The Hawaii Supreme Court has been very clear that there is no property right of exclusivity in Hawaii. So they're saying our examination of the relevant legal developments in Hawaiian history leads us to the conclusion that the Western concept of exclusivity is not universally applicable in Hawaii. In other words, the issuance of a Hawaiian land patent confirmed unlimited property interests as compared with typical land patents governed by Western concepts of property. So to understand what this means, like what Western property means as compared to property in Hawaii, is often to understand property law, general property law in the Western world, is to understand that there's these bundle of sticks or bundle of rights that landowners have. And so there's these bundle of sticks include the right of control or use, the right to use what you own, the right of benefit, to make profit from one's property, to make economic use of it, the right of transference, the right to give or sell property when one no longer wants to own it, the right of destruction. An owner has a right to enjoy and do with his property as he pleases, even to spoil or destroy it, as far as the law permits. Okay, so that's like coal mining, that's like quarrying. Even though you put a big hole in the ground and you got toxic waste flowing from that, as a property owner under Western construct, you have a right to destroy your land. And then there's the right of exclusion. A property owner can legally prevent other people from using, benefiting from, transferring, and destroying his land. So it's like, think of the, the Appalachian guy, hillbilly with his gun and going, get off my land. So that makes sense on the mainland, but it doesn't make sense in Hawaii. And so in the past case, the court was clear that, we're not taking your property without just compensation, because the property you own in Hawaii is not subject to all this bundle of sticks, and principally that stick of the right to exclude or alienate your property from, basically to exclude others from utilizing your property. So the other source of law is Hawaii Revised Statute 1-1, where it was called the Judiciary Act. So the actual language is the common law of England as ascertained by English and American decisions, is declared to be the common law of the state of Hawaii in all cases. At that time, it was named the Kingdom of Hawaii, except as otherwise expressly provided by the Constitution or laws of the United States or by the laws of the state, or fixed by Hawaiian judicial precedent or established by Hawaiian usage. So what does that mean? What it means is common law is the decisions, court decisions. So they're saying in Hawaii, we look to England's and America's judicial decisions for guidance, except where they conflict with Hawaiian judicial precedent and Hawaiian custom and usage. So if they conflict with Hawaiian cases or Hawaiian custom, then the Hawaiian custom will trump. So what is this usage thing? So it was more the customs of the Hawaiian kingdom, the national usage. Okay, so that the custom and usage provision survived into statehood. It began in 1840 under the kingdom, where the rights of native tenants were established in the first constitution. In 1845, during the time of the Mohele, when the Board of Land Commissioners were resolving competing land claims, its decisions were required to be consistent with native customs. While private interests in land were created, the king retained the right to regulate undeveloped land that would not leave native tenants destitute. Courts recognize principles of common law, or basically judge-made decisions, but they limited their sweep to circumstances where they did not conflict with native usage or kingdom law. Thus, ancient Hawaiian usage survived the transition from communal land tenure to a Western system of private property rights. And the third act of Kamehameha III created an independent judiciary in 1847 and authorized the adoption of common law principles of England and America, provided they were not in conflict with the laws and usages of this kingdom. Okay, so that is the history of what is now called Hawaii Revised Statutes, or HRS 1-1. Okay, so the statutory laws existed from kingdom period and represented the customary practices prior to the kingdom becoming established. And in 1978, when there was a state constitutional convention, what occurred was the promulgation of Article 12, Section 7, which basically reaffirms and protects these rights customary and traditionally exercised for subsistence, cultural and religious purposes, and possessed by Ahupua'a tenants who are descendants of Native Hawaiians who inhabited the Hawaiian Islands prior to 1778, subject to the right of the state to regulate such rights. So what does that mean? What it does is it elevates Native Hawaiian traditional, customary, and religious practices to fundamental rights protected under the Constitution. Therefore, government has an affirmative obligation to protect these rights. So what it does is it strengthens the laws, the statutes of, that come from HRS 1-1 and 7-1. So another important thing to note, the difference between the Kuleana Act, known as Section 7-1, where it identifies specific things that the people had a right to gather and access. So is this the universe of all Hawaiian practices, would you say? Or are there other customary practices that exist? So I would say that there are way more Hawaiian practices than gathering these items. Okay, so what HRS 1-1 does is it's a catch-all. It also encompasses other practices that are Hawaiian cultural practices and customs. So this picture is of people picking opihi in the intertidal zone. Is picking opihi or limpets a Hawaiian cultural practice? Yes, it is. There are people who pick opihi on every island. So is the picking of opihi enumerated in the Kuleana Act? It's not. So what HRS 1-1 does is it encompasses other customs, yeah? But how do you figure out what is a Hawaiian custom? Okay, so I'm going to introduce you to the case called Ashford. And this picture of a canoe parked on the beach will be significant once I explain this case called Ashford. So this is a Molokai case. Ashford was an attorney and he bought beachfront property. And he wanted to make a claim by which he could have his own private beach. So in that case, the original land grant used the phrase makekai, which means along the shore. So this case was decided by the Hawaii Supreme Court. And at the time, Chief Justice William S. Richardson sat on the bench. So he presided over the Supreme Court, and he was a Native Hawaiian. So I remember when he visited my class when I was a law student. He said, like, he looked at what was the custom. and a simple question of where do you park your canoe? Do you park it with the highest wash of the waves, that high water mark, or is your canoe gonna be swept out to sea? So, or do you park it at least above the limo line where the debris of limo is, or better yet, where the vegetation is, where the naupaka grows? And so it was the Kama'aina, the people of Kainalu Ahupua'a, who were from that area, that said, no, I would park my canoe where the naupaka is growing. And so what Ashford wanted to do was, what he did was he got a USGS trained and licensed surveyor who basically said, highest wash of the waves. And what happened was the court decided to listen to the Kama'aina, the common people of the land, the old timers. And basically after that, there's no private ownership of beaches in all of Hawaii because of the Ashford case. So what the court did was quote some other cases. I believe it was INRI Boundaries of Pulehunui that they quoted. So they said Hawaii's land laws are unique in that they are based on ancient tradition, custom, practice, and usage. It is not solely a question for a modern day surveyor to determine boundaries in a manner completely oblivious to the knowledge and intention of the king and old-time Kama'aina, who knew the history and names of various lands and the monuments thereof. In this jurisdiction, it has long been the rule, based upon necessity, to allow reputation evidence by Kama'aina witnesses in land disputes. So this is really significant. So who interprets Hawaiian custom and usage is the Kama'aina. And then if you recall, when I showed you these Mahele maps, so basically during the Mahele, land was pretty much just the royal patents and land commission awards. Things are given by name only. And so they had to have a land commission to determine the boundaries. And so they would get Kama'aina experts, people from that area, to attest to where the boundaries or palena are. So that's why in the Ashford case, they're saying, it has long been our practice to look to Kama'aina to determine the names of various lands and the monuments thereof. So it elevates Hawaiian Ike to that of being an expert. And you don't usually see this in, Western courts, yeah? So the way that I try to make my students remember these things is I sing to them the Ghostbuster song. Who you gonna call? Ghostbusters. But it's like, if you wanna know the Hawaiian custom, who you gonna call? Kama'aina. You're gonna call the Kama'aina to determine what is the custom. Okay? So one of the more seminal cases is another case that came out of Molokai, and it was Kalipi versus Hawaiian Trust Company. And the late Uncle Billy Kalipi owned a taro field in Manawai and adjoining house lot in Ohia, East Molokai. He had sought to gather certain items for subsistence and medicinal purposes within the ahupua'a, but was denied access by large ahupua'a owners. Okay, so just to give you a visual of what Uncle Billy Kalipi was saying. So Uncle Billy lived really pretty much close to where I lived. And he had certain rights through several ahupua'a because of his family connection. So this is Wavecrest. Wavecrest, it's kind of like a condominiums area. And so where the tree line is above, this is Uncle Billy Kalipi's Kuleana land. So he had a house lot and an ag lot, and they were adjacent. It was like putting two tables right next to each other. So what the court is saying is that he owned one part of his kuleana was in the two parts of his kuleana land straddled two ahupua'a. Okay, but he ended up marrying a woman who lived in Kiawanui. Kiawanui is right next door, right here. So he basically just moved down the road, like not even a mile away. But he wanted to gather in Manawai, Ohia and Manawai, where his kuleana land existed, his house lot and his taro patch. Okay. So that's just to set up the thing for you. And just to let you know how so close these ahupua'a are. If I was a pro football player or a pro baseball player, I could throw a baseball or a football through three ahupua'a, through Manawai, Kahananui, and reach Uhalapue. So these ahupua'a are just so narrow and close together, yeah? So practically on the ground, this decision that the court made did not make sense, okay? So going back to the Kalipi case. So the Hawaii Supreme Court provided this test. The tenant must physically reside within the ahupua'a from which the item is being gathered. The right to gather can only be exercised on undeveloped lands within an ahupua'a. The right must be exercised for the purpose of practicing Native Hawaiian customs and traditions. Okay, so going back to the map, going back to the aerial view. So because Uncle Billy did not reside anymore, physically reside in Manawai and Ohia, but lived with his wife down the ahupua'a right next, he said, you don't have a right to gather. And then they said, Hawaiian gathering rights make sense on land that is undeveloped. Otherwise, we're gonna be clashing too much with large landowners. We have this competing interests. One, private landowners need to feel secure in their property, but also native tenants must preserve their right to gather within their ahupua'a. So Mr. Kalipi lost in that case. But what the Kalipi case did was it set up the dynamics for future cases. So because he didn't actually reside within the ahupua'a that he claimed the gathering right for, the court said you cannot gather in this area. Okay. But at the same time, the court wanted to say, even though any argument for the extinguishing of traditional rights based simply upon the possible inconsistency of purported native rights with our modern system of land tenure, so Western property law kind of constructs, must fail. So the court said, we're not gonna only recognize private landowner rights. We're gonna still protect Native Hawaiian gathering rights, but only on undeveloped lands and where the native actually resides as a tenant or ho'aina on those lands. But then you got to think of cases as a mo'oku'auhau, as a kind of genealogy. The court doesn't always contemplate additional situations. So what the court has to do is try and harmonize these cases, especially if they have kind of different fact patterns. So in the Pele Defense Fund case in 1992, it had to do with geothermal, the location of a potential geothermal plant. And it was in the Puna region in Va'okeleo, Puna. But the people living in Puna, they asserted gathering rights to certain ahupa outside of their ahupa of physical residence. There are also people like in Kau that would access the forested area, the Va'okeleo, Puna, where no one lived, for gathering, things from the forest. So I know like one example is Papa Henry Awai. He utilized Va'okeleo Puna for La'au Lapa'au, for traditional medicine. He could only find certain plants in that area where they were going to put the geothermal plant. So then the court had to think like, well, okay, nobody lives here, but clearly there are Hawaiian practices occurring here. And it's by Hawaiians that don't live in this area, and nobody lives here. So then it made them, they kind of put them in a conundrum in terms of the Kalipi case, because they said you gotta actually reside in that ahupua'a. But what the court did was they expanded their understanding. They brought in their understanding of what these sources of Hawaiian law protects. And they said that access and gathering rights may extend beyond the ahupa of residents upon proof that such customarily and traditionally exercised subsistence and cultural activities were actually practiced by Native Hawaiians prior to 1892. So this 1892 part of it has to do with the Judiciary Act, or what became HRS 1-1. So prior to, just before the overthrow of the kingdom in 1893, the Judiciary Act passed its latest update. The legislature, the kingdom passed its latest piece of legislation on the Judiciary Act. So that's why it says 1892. And this will be significant when we go over the Pash case. So what the Pele case did was broaden the understanding of where Hawaiian rights may exist. Okay. And what they did was they tried to distinguish from the Kalipi case by saying, well, Kalipi based his claim strictly on his land ownership. So we're looking in Pele as to the actual practice of that area. Okay. So then came along public access shoreline Hawaii, and it arose out of a contested case hearing, or an government agency hearing, whereby the Hawaii County Planning Commission was issuing a special management area permit. So this is permits that are usually issued for use along coastal areas. So there was a developer called Nanse who wanted to get this permit to build kind of a resort development in this area in the Kona area of Hawaii Island called Koanaiki. And so there was this group called Public Access Shoreline Hawaii, or PASH for short, that had environmental members as well as Native Hawaiian membership. And they sought to intervene on the agency level. But one of the things that's required is to determine whether those trying to intervene or sue or stop a project have what's called standing. So standing is, are you being actually harmed? Is your harm different from the general public? So if you're going to be harmed by this action, then you have standing to bring this case. So what the Planning Commission said is, Native Hawaiians, your rights is no different from the general public. And even though some of your members are saying that you catch opai, opai ula, which is a native, kind of a transparent native shrimp, reddish in color. So even though there's evidence of Native Hawaiian cultural practitioners gathering opai ula in these ankyline ponds, so they're like lava-like kind of taipu areas that's fed with fresh water and salt water mixture. Is saying, even though these you have this practice on this land, we don't see Hawaiian rights as any different from the rights of the general public. So what the agency did, what the planning commission did, was denied a contested case hearing. So since they lost at the agency level, PASH appealed in the court system, and it went all the way up to the Hawaii Supreme Court. And what the Hawaii Supreme Court said, you erred, the agency erred or made a mistake in not granting these Hawaiian practitioners standing. So what it did was it cited Article 12, Section 7 of the state constitution and HRS 1-1, protecting Hawaiian custom and usage. So what Nanse, the developer, tried to do was provide a very rigid definition of what is Hawaiian custom. And so she said, the developer, Nanse, said, for Hawaiian custom to be recognized, that practice has to be proven to have been done since time immemorial. So what does that mean, time immemorial? Time immemorial means before the memory of man, like, was so long ago, I don't even know when it started. So what Nancy tried to do is kind of say, like, this practice, you have to prove that it goes so far back to time immemorial, and that it needs to be uninterrupted, continuous. So if there was any kind of gap where the practice wasn't being done, then it should fail to be considered a Hawaiian custom. And then there was like, this is unreasonable because this interferes with my property rights, my private property rights. And you better be really certain that this is an actual custom, because it's harming me as a landowner. And so what the court said is, we're not going to adopt this very rigid definition of custom that you're trying to propose, developer. The Judiciary Act, the final iteration of the Judiciary Act before the overthrow of the kingdom, was in 1892. And Hawaiian custom is a living thing. Hawaiian people are living, they have a living culture. And the Hawaiians may have adopted customs that weren't in existence prior to the founding of the kingdom. So we're gonna look at custom more fluidly. If it was established prior to 1892, then that's fine. Not this time immemorial standard. And then this thing about continuous, the court said, no, these customs can be renewed. It's just harder to prove if there is the lack of continuity or consistency, but it's not impossible to prove. So what you got to think about is, like, a lot of the fresh waters have been diverted from windward valleys, from the watershed into drier areas on the leeward side of different islands like Maui, like Kauai, like Oahu. And so what happened in those instances was it really impacted taro cultivation, and a lot of Hawaiian families were forced to move into the city, and so they didn't farm taro anymore. But now you're having water cases where now that there's the end of sugar cultivation, there's a lot of Hawaiian families suing to have the waters returned to the windward watersheds. And so now with some water returning to these areas, kalo cultivation is more viable. So are you gonna disallow Hawaiians from going back to the land and growing kalo? So that's one example. So the court, I believe, was thinking about these things and said, no, you can renew your cultural practice. You don't have to be practicing it so consistently to show you have a right. And then reasonableness is not, we're not gonna base it on your rigid definition of it's unreasonable to you. And it's, this Hawaiian custom should be certain in the sense of how it impacts you, developer. The court said, no, reasonableness, we're gonna look at it is at whether there's no good legal reason against it. So we're not gonna have this high bar that Hawaiians have to jump in order to say that what they're doing is a custom. Certain, it cannot be on some subjective evaluation. It has to be objectively defined and applied. And yes, these are competing interests, but the state has the authority to reconcile those competing interests. And we're going to look at the individual circumstances in each case to make that determination. So the other thing too is the land was also not necessarily undeveloped, but it was somewhat developed. But clearly Hawaiian practices were still taking place on that land. So what the court did was expand the Kalipi ruling to say, okay, Hawaiian gathering rights exist on undeveloped and less than fully developed lands. And basically the court says, this constitutional obligation that we have and this obligation to follow these statutory laws means that we don't have this unfettered discretion to regulate Native Hawaiian rights out of existence. So basically government cannot regulate Native Hawaiian rights out of existence. And then Nansei said, if you allow Hawaiians on my land to gather and access, you're taking my private property without just compensation. So under the Fifth Amendment of the United States Constitution, it elevates the rights of property owners to a constitutional or fundamental right. So basically Nansei is saying, you're not allowing me to exclude people from my property. And Western property law says I have these bundle of rights or this bundle of sticks. And one of them is the right to exclude people from my property. If you're not allowing me to exclude Native Hawaiians from my property, then you're taking my property without compensating me for it by this draconian regulation of yours. So that's what's called like a regulatory taking. But as I said earlier, the past case said, the way the Mahele was set up, it didn't give people exclusive rights. The land is burdened by these rights of native tenants. We have the Kuleana Act that says people can go gather within the ahupa to get what they need. And we have this Judiciary Act, now named HRS 1-1, that says, where Western legal decisions conflict with Hawaiian custom, we're gonna pick Hawaiian custom over the Western law. So that's the basis and rationale behind cash. They said protecting Native Hawaiian gathering rights is not a taking of private property. Not all the bundle of sticks were conveyed at the time of the Mahele, namely the right to fully exclude and alienate people from your land. So the other seminal case was Kapa'akai o Ka'aina. And this had to do with a request to change or reclassify lands from conservation to urban in order to build a Ka'upulehu resort in Kona on the Big Island. So, the past case had already been litigated in the 90s. Now we're in year 2000. So the agency knew that it had to hear the concerns of Native Hawaiians. So there was a contested case hearing, and they took evidence of what the people were saying their practices were in Ka'upulehu, and that was, the practice of gathering pa'akai, gathering salt along the shoreline. It included, access to native burials. There were native trails there. There were cultural sites there. They also gathered pelestiers. So the agency, the Land Use Commission, documented the testimony. But the developer said, look at our cultural management plan. We're making accommodations for cultural practice and, environmental, the public guys that want to do environmental, recreational kind of stuff. So, you should just approve our plan. And so what the Land Use Commission said, yeah, we like your plan. We think it protects Hawaiian rights. So yeah, we'll approve this project. So it got appealed and went all the way up to the Hawaii Supreme Court. The court ruled that, you can't just adopt verbatim the developer's plan. You have to do an independent analysis, because the state constitution requires you to have an affirmative duty to protect cultural rights and practices. And you cannot abdicate your kuleana or your responsibility to the landowner or developer to protect Hawaiian rights. You as an agency have to have an affirmative obligation to do your due diligence, basically. And so what came out of this case was a 3-part test, which, we call the Kapa'akai framework. And what it does is it requires the agency to do an inventory to identify what are the valued cultural, historical, or natural resources present on the subject property, and including the traditional and customary Native Hawaiian rights and practices exercised in that area. And then the agency has to look at what would be the impact on these resources, rights, and practices of Native Hawaiians if the development project is approved. So impact, what's the potential impact? And then third, they have to insert conditions to mitigate harm to the resources and the Native Hawaiian rights and practices. Okay, so I use this very easy pigeon type test. What get, what gonna happen, and what you gotta do to make it pono. So what get is, hey, what kind of resources are in this area? Are there any Hawaiian practices that we gotta protect? So what get? What gonna happen? What's the impact? What gonna happen if we build this resort? Or if we approve this plan that the developer has? What gonna happen? And then if I know what's gonna happen, then how can I prevent harm? How can I make it pono? So what gonna happen? How do I make it pono? How do I balance these rights? Okay. So that's a Kapa'akai framework. So more recently, there was the Mauna Kea case, and it was going a lot through the courts, but the one that I want to look at specifically is what they call Mauna Kea 2 2018 decision. So this had to do with the State Board of Land and Natural Resources. They're given the responsibility to issue permits for use in the conservation zone lands. So Mauna Kea, where there was a proposal to construct a 30-meter telescope for astronomy studies. It's quite a sizable development on conservation lands. And the board issued a conservation district use permit to allow for this 30-meter telescope. Basically an 8-story high, super huge telescope on the top of Mauna Kea. And so the Hawaii Supreme Court upheld the board's decision, finding that the Kapa'akai framework was properly applied. But the court disagreed with the Mauna Kea protectors on their argument that the board did not protect contemporary Native Hawaiian cultural practices. While the erection of ahu along the summit road in protest of the TMT project may be considered a cultural practice, the court found this practice to be unreasonable. So the court also disagreed with the Mauna Kea protectors' assertion that BLNR, the Board of Land and Natural Resources, failed to consider cultural resources and practices surrounding the TMT project area. The court found in the administrative record evidence that the board actually made specific findings that also identified and considered the effect of the project upon cultural practices in the vicinity of the relevant area and in other areas of Mauna Kea, including the summit regions. The court also addressed issues surrounding the public trust, which you will hear about in the other lecture, which is also protected under the state constitution. Contrary to prior case law on the public trust, which calls for the conservation of natural and cultural resources, as well as the protection of Native Hawaiian traditional and customary rights, the Hawaii Supreme Court found the construction of the TMT to meet a public trust purpose. Despite prior public trust cases that identified commercial uses as not serving the public trust, the court in this case found the building of a world-class telescope on conservation land would benefit the public through the advancement of science. The court found that 2.5 million in community benefits package for scholarships and STEM education and the generation of jobs would also directly or indirectly benefit Native Hawaiians. Furthermore, future mitigation measures that would involve decommissioning outdated telescopes would meet public trust requirements. So this case may signal a shift in the court's outlook towards Native Hawaiian rights and the public trust in terms of the heightened scrutiny afforded by the state constitution and showed in the other cases I talked about. So with the court's deference to the board's decision and rationale for granting the CDUP for the TMT, its opinion may embolden governmental agencies to relax standards of review expected of trustees on behalf of the natural environment and Native Hawaiian rights. But after this case came the Pohakuloa case. And the Pohakuloa case kind of advances this understanding of a right to malama. So in that case, which I don't think I have a slide for, it had to do with that, with the military exercises occurring in Pohakuloa, and these two kupuna suing and stating that the government in leasing that land to the military also had this affirmative obligation to ensure the care for those lands, and in not having some kind of management plan and implementing that, they breached their duty as trustees. So this Mauna Kea case doesn't necessarily make sense when you look at the Pohakuloa case. So I think there was some political pressure placed with the Mauna Kea case. So these cases, they're categorized as civil matters. Okay, but now we're gonna look at how does the burden shift. So in the civil cases, you see, like, there has to be some kind of proof, like in these administrative hearings, these agency hearings, like the Pash case and Kapa'akai, where it's before a government agency. They have this sort of affirmative duty to protect Hawaiian rights. Okay, and they gotta show that their actions is not gonna infringe on Native Hawaiian rights. But what happens in criminal law situations where the Hawaiian is now the defendant, having committed some kind of crime under the Western understanding, but invokes the Article 12, Section 7, protecting Native rights as a thing that mitigates the charge, the criminal charge. So it's used as a constitutional defense by Native Hawaiian defendant. Okay, so what I want you to look at is how do the standards of review and who has the burden to prove the Hawaiian right in criminal law cases where the constitutional provision is invoked for immunity. So the first criminal law case was State versus Hanapi. Again, this was a Molokai case. And Uncle Alapai Hanapi of Ahaino, Ahupua'a, on Molokai, East Molokai, resided next to these twin fish ponds, Kihaloko and Vaihila, where he and his ohana practiced Native Hawaiian religious gathering and sustenance activities. So the late Gary Gallagher, when he was alive, he was an asbestos attorney. So if you remember all those like commercials for asbestos litigation, that was Gary Gallagher. So Gary Gallagher purchased land, Malka, and adjacent to the Hanapi's Aina, and illegally graded and filled the area near the fish ponds to build a boat landing. So Hanapi viewed these actions as a desecration of a traditional ancestral cultural site and reported the illegal grading of a wetland area to the U.S. Army Corps of Engineers. The Army Corps of Engineers agreed with Hanapi and ordered Gallagher to restore the property. So Hanapi wanted to make sure that in the restoration activity that Gallagher wasn't doing more harm than good. So he went on the property to observe and monitor the restoration activities. And it included removing the fill and regrading with a bulldozer. So on the third day, Hanapi witnessed the bulldozer operator pushing fill into a punavai, or freshwater spring. The dozer operator claimed it was water collected in a hole left by an uprooted tree. So Hanapi said, hey, you need to stop. And the dozer operator ordered Hanapi off the property, saying, this is private property, you're trespassing. So Hanapi refused to leave and the police arrested him for criminal trespass. But Hanapi ended up defending himself pro se in court without an attorney, okay? So it was difficult for him to introduce evidence because You have to introduce evidence in a certain way. And people who are lay people don't necessarily have that skill that lawyers have in properly introducing evidence. So he had difficulty, you can find in the court record, he had difficulty proving that what he was doing was a Hawaiian custom. So he was trying to say, I'm trying to malama this place. So what I was doing was a Hawaiian thing. I was doing malama. So what the court did was they made a test, that the claimant, if it's in a criminal context, then the defendant, the Native Hawaiian defendant, has that burden to prove that what he was doing was constitutionally protected as a Native Hawaiian right. So first, the claimant, the defendant, has to prove that he or she is a Native Hawaiian. So this definition of, do you descend from the people who inhabited Hawaii prior to 1778 when Captain Cook first arrived? So do you descend from the Aboriginal, indigenous ancestors of Hawaii prior to Western contact? Okay. And then you gotta provide an adequate foundation connecting your claim right to a firmly rooted traditional customary Native Hawaiian practice. And you have to show that the exercise of your claim right occurred on undeveloped or less than fully developed land. So because Hanapi had difficulty introducing evidence and the trial court record was very thin, the Hawaii Supreme Court said, Mr. Hanapi failed to meet that second requirement, which was to provide an adequate foundation that his actions of what he said, malama aina, is a traditional and customary Native Hawaiian practice. So in this case, Hanapi lost. So what you're gonna see is a lot of these cases of a criminal nature has to do with malama aina. The prior cases is about access and gathering rights. But when there's this sort of malama aspect, and especially if you're going up against the state, it's harder for the state to relinquish that kind of control. And so a lot of Hawaiians get arrested and prosecuted in the act of trying to protect and to malama aina. So now let's look at the next case is State versus Pratt. Okay, so Pratt, Kauai Pratt, Lloyd Pratt is a Native Hawaiian. He camped in Kalalau Valley on Kauai for prolonged periods without obtaining a camping permit. He spent time in the valley cleaning hail, growing kalo and native plants, clearing brush, and taking out garbage. So he was convicted for illegally camping without a permit. Okay, so what occurred basically was Kalalau was a kahu. He was like a kahu is kind of like a priest or guardian. So he was raised by his family to malama, and where this state wilderness park, the Kalalau State Wilderness Park it was formerly his ancestral land. And it took a long hike to get to these lands. So he would stay for prolonged periods. And so because of the Hanapi case, we didn't want to lose again in an issue that had to do with a criminal law issue that had to do with malama. So that issue of providing an adequate foundation was really important. Okay, so an expert witness was called in, and that was Professor Daviana McGregor. And her research and scholarship is around looking at the rights and practices of Hawaiian native tenants. So she identified 6 elements essential to traditional and customary Native Hawaiian practices. The purpose is to fulfill a responsibility related to subsistence, religious, or cultural needs of the practitioner's family. The practitioner learned the practice from an elder. The practitioner is connected to the location of practice, either through a family tradition or because that was the location of the practitioner's education. The practitioner has taken responsibility for the care of that location. The practice is not for a commercial purpose. The practice is consistent with custom. So Dr. McGregor concluded that Pratt's conduct met the requirements of a traditional and customary and religious practice. The planting of food was for subsistence. The ceremonies he performed at the heiau are considered Hawaiian religious activities. He learned these things from his elders who passed the knowledge down from the ancestors who lived in Kalalau. All these things are consistent with Hawaiian custom. So again, we go to the Hanapi case. Was Pratt Hawaiian? Yes. Is there an adequate foundation in the record connecting the claim right to a firmly rooted traditional or customary Native Hawaiian practice? According to expert witness Professor Daviana McGregor, yes, there is an adequate foundation. And did these practices occur on undeveloped or less than fully developed land? This was a wilderness park, so yes, he met the 3 prongs. So what do you think was the actual outcome of this case? Do you think Mr. Pratt won or did he lose? I want you to think about that for a moment before I go to the next slide. Okay, so what happened was he lost. How come he lost? Doesn't make sense. He met all the 3 prongs in the Hanapi test. Well, the court said the court had certain reasons why they felt Mr. Pratt should be cited. They had certain rules and regulations on the park use. And that was, we gotta meet health and safety concerns. So we have a fixed capacity of people that can go to the park, because we have compost toilets. If we allow every Hawaiian to stay indefinitely, it's gonna compromise our health and safety with, overuse of the compost toilets. We have to protect vulnerable park uses, resources, native plant and animal life. And we have to maintain low density and the wilderness experience. So think about also the issue of indigenous peoples living like in the Amazon. Is that a wilderness or is that just a rendering of Western belief in conservation, that lands are pristine and there's no evidence of native people on that land? It's wild. But clearly you have Mr. Pratt, whose family lived on those lands and made it Aina Momona. So are these wildlife areas really, are these wilderness areas really untouched, pristine? Or was it such that the native people of that land just understood how the ecosystem worked and did things in alignment with that? So it's important for this class to really think of what is conservation. This class is about natural resource issues and ethics in Hawaii. Is Aina without people? Or can you separate the native people from the land when you look at management? Yeah. So basically, the state argued its right to regulate Native Hawaiian rights under the Article 12, Section 7 of the Constitution. And the state also argued that it already has a curatorship program to manage cultural and archaeological resources, including heiau. The state argued that its curatorship program helped to reconcile competing interests in managing the park. The ironic thing about this is Pratt had actually requested of the Department of Land and Natural Resources to be part of this curatorship program. But the state did not respond. So he took it upon himself to malama. For him, it's my kuleana to take care. Whether you tell me, whether you allow me or not, I'm going to take care. So the state invoked this curatorship program to say that, we can reasonably regulate Native Hawaiian rights under the Constitution, and Pratt had an alternative. He could have been part of this program. But they failed to mention that Pratt actually applied to be part of the program, and they were negligent in responding. Okay, so you have issues where Hawaiians are trying to malama, the state has been silent or resistant, yet there is a need to malama, okay? So in this case, the court confirmed the Hanapi factors as a minimum test for defendants to meet in claiming a constitutionally protected Native Hawaiian traditional and customary right. But as I said earlier, under Article 12, Section 7, the state has a right to reasonably regulate Native Hawaiian rights. So the state has to balance the protections afforded Native Hawaiians while also considering countervailing interests. So basically, what the Pratt case did was add this extra layer that in the Hanapi case, it wasn't necessary to look at because Hanapi didn't meet those three factors. So, these interests are weighed according to the totality of the circumstances on a case-by-case basis. So the court reserves its discretion to look at other scenarios before they make some really definitive tests. So they upheld the conviction of Pratt and said that he could have consulted with the state in the malama aina activities he undertook, and he should have acquired a camping permit, which is a reasonable regulation. Okay. So another case is Armitage. Okay, and this had to do with the island of Kaho'olawe, which has special rules for their use because there's unexploded ordinances on that land. There's safety concerns. The Kaho'olawe Island Reserve Commission manages Kaho'olawe. It was used in the past by the U.S. Navy for bombing practice. But under the first President Bush, the island was given to the state's management through the Kaho'olawe Island Reserve Commission. And it will be ceded to Native Hawaiians if we have a governing entity at some point. So in this case, 3 Native Hawaiian defendants were charged for the commission of a petty misdemeanor for entering Kaho'olawe without having filled an application form and receiving authorization from the Kaho'olawe Island Reserve Commission, or KERC. So the administrative rules details the process for obtaining approval from KERC for entrance into and activities within the reserve by applicants seeking to exercise traditional and customary rights and practices. The defendants entered Kaho'olawe as citizens of the reinstated Kingdom of Hawaii for the purpose of claiming property rights to Kaho'olawe and to build an ahu and offer prayer on the island. So the court held that the balance weighs in favor of the state's interest in protecting the health and safety of those individuals who travel to Paho'olawe. So when we convene class live, I'm gonna break you guys into breakout rooms to go over different scenarios and see, now that you understand Native Hawaiian rights law, how do you apply it to these hypotheticals? So with that, mahalo, and I will see you in class. Aloha.